Awesome. Well, hello everyone that's watching on Facebook. We are having a judicial forum tonight to hear from our candidates. As we know that our judicial races are so important this year. So encouraging everyone to go vote and vote all the way down your ballot for your local judges. As I like to say, this year judges race matter. So I'm so excited that all of you have joined us today. I will be joined today as well as a co-host as Zaria Davis, and I'll let you introduce yourself, Zaria.
Good evening, everybody. My name is Dr. Zaria Davis. I am one of the lead organizers with the All of Us or None chapter, which is an organization that is led by formerly incarcerated and directly and indirectly impacted individuals. And so I just want to thank you all for being here and being a part of this conversation this evening.
Thank you, Dr. Zaria Davis. And so we'll let all of the judges have and candidates have a chance to introduce themselves, and I'll just call you as you appear on my screen. Just tell us a little bit about your background, who you are, what court you're running from, and what type of decisions does that court make. And we'll start with Allison Hathaway.
Thank you. My name's Allison Hathaway. I am running for Hamilton County Court of Common Pleas, General Division. That's the court that hears, felony adult cases and civil cases over a certain dollar amount. They do a lot of work. They, make decisions around the rules of the court and how things are administered. They do all of that as well. I am a longtime public defender. I did have a career before I went to law school and started practicing law. I was a news reporter, and I actually worked at 700 WLW for a number of years. I actually worked there and went to law school at the same time. So I worked full-time, went to law school part-time, and I eventually left the world of radio news, and I joined the public defender's office. I started on the front lines as a trial attorney. I have a lot of litigation experience. I started in the juvenile division. I worked in municipal. I've tried cases in felony common pleas court. And now I'm the director of the juvenile division at the public defender's office. I'm also a point of contact for a $425,000 grant from the U.S. Department of Justice, where we were able to bring a holistic defense model to the juvenile division of our office, which included social workers, and we're trying to launch a participatory defense network here in Hamilton County for youth involved in the system. Hopefully I didn't go on too long, but thank you again for having me.
Thank you. And Kurt Hartman will be next.
No problem. Thank you, Celeste, and thank everyone for being here this evening. My name is Kurt Hartman. I'm also a candidate for the Common Pleas Court General Division. There are 8 separate races in that division. And so other people here tonight, we're not running against each other, but we're here to kind of give you an overview as to our positions. As Allison indicated, the General Division handles the felony criminal cases as well as the larger and significant civil cases. My background, basically, I've been practicing an attorney and former judge for about 25 years now. And during that time, first at some big law firms, but then I went out on my own, where I was representing individuals, did criminal defense work, trials at that level, as well as criminal appeals. And when I got on the bench, and so I kind of took that as my background when I came onto the bench. And I think you recognize when I got on the bench a commitment to fairness and justice, that, it wasn't a presumption in favor of the prosecutors or the defense. It was there to do justice, to give everybody their day in court, to give them the right to a hearing, the right to their constitutional rights, to a fair hearing, a fair jury. And I think I established myself with that great reputation. So looking to get back onto the bench and to continue to promote the fair and impartial administration of justice. Thank you.
Thank you. And Judge Burke will be next.
Good evening, everyone. I'm Kim Burke, and I have been Hamilton County's drug court judge since 2001. Drug court is a little bit different than general division. I am a general division judge, but it will say separately drug court on the ballot. What drug court does is it helps people who have intersected with the criminal justice system by having a felony possession of drugs case or a changing of a prescription case, illegal processing of drug documents or deception to obtain drugs. If you have been charged with a felony possession case and you have an addiction, or you are open to be evaluated to see whether or not you have an addiction, then what drug court does is it provides you with resources and tools that would allow you to address your addiction in a way that's healthy. But in addition, we provide access to I call them surround sound services, but basically they're services that help the person get reintegrated into society in a meaningful way. So you will have a job. We will help you with your family. We will help you with your housing. The purpose of drug court, and drug court started a long time ago in Miami when crack cocaine was coming from Colombia, I think, and it was overwhelming the system. And what the people who were involved in law enforcement found out is locking somebody else doesn't do a darn thing for their addiction. It's just it's a revolving door that didn't work. So in 1989, some people got together and said, why don't we deal with the underlying issues that people who possess drugs have? And a lot of time that's addiction. And that addiction became a crime in that it was intersection with the criminal justice system. Here in Hamilton County in 1995, drug court started. I have been drug court judge since 2001. And what I do is I help people get the tools that are necessary to lead productive lives. And I know what the challenges are and with people who have felony drug convictions. I try very hard. If I don't have to give somebody a felony conviction, I don't do it. There's a mechanism called intervention in lieu of conviction, whereas if you have certain qualifications, basically no prior felony, once you go through treatment, this can be wiped off your record. And even if you do have prior contacts, the way that the expungement law now works, if you wait a couple years, you will be back before me. And I have not denied a request for expungement for someone who went through or made an honest effort through our program, because I recognize the challenges that are there. Drug court, I think, really, you need to have someone who sees people as humans and somebody who is compassionate, because the journey through this is not perfect. I don't know any perfect people. I say, if you know one, let me know. I'll go to the seminar, I'll learn something. But what I do know is that I see our clients. I am dedicated to helping them. And I am not a person that says, oh, you made a mistake and then you go out on your way. I give lots and lots of chances in there because I know that life is hard and we've all come from different places. I'm very proud of the success of drug court. I love to talk about it, but that was just a little bit of an introduction. I've taught judges across the country. I was a faculty member for almost 6 years at the National Judicial College. I was one of the persons that helped write the rules and regulations to train other judges how to be specialty court judges. I've even written the bar exam. So I'm old, I'm 62. Proud of it, because you know what, every day is good. But I have a lot of experience, and I think that experience really helps. So thank you, and I hope I didn't talk too long.
And last but not least, Judge Bearden.
Thank you, Mistress. I appreciate you having me here today. I appreciate hearing from everyone else on the panel. I am also running for Common Pleas Court's General Division. I am running for re-election this year. I filled an unexpired term back in 2018. And because of that, I have to run again this year in 2020. Echoing a lot of what everyone else said, for the Common Pleas Court, we do handle the major crimes. When I talk to people normally, they think of law and order, and that is usually what we're dealing with, murder, kidnapping. But also, as Judge Burke brought up, we do deal with a lot of drug issues. The majority of my court is dealing with issues that arise from drugs. We also deal with, as Mr. Hartman said, civil cases over $15,000 and complex civil litigation, because we do not have a commercial docket anymore. So there are a lot of different cases that come before us. That's why it's important to have judges who have experience. I started out as Ms. Hathaway is right now as a juvenile public defender. I never rose as high as she did as supervisor, but I was then able to go to the city and be a prosecutor, where I was then a solicitor for the city, where I did civil work in common pleas court. So bringing that experience to the court is important. It lets me treat everyone with respect, because I have some understanding of where they're coming from and why they're in front of me and why they're making the motions that they are. Having represented defendants before, especially juveniles, it definitely gives me insight to people who appear before me and makes me more conscious of plea agreements that come out with criminal cases and everyone's right to a jury. You have clients who want to have a jury. That's their constitutional right. And as judges, it's important that we enforce those rights and enhance them, letting people who know that they come into our courtroom that they have the right to have a jury trial. It is not an imposition on us, and that we will have those cases and take the time to hear them and hear them correctly. So thanks again for having me here tonight. I can't wait to talk some more about the courts.
Awesome, thank you. And so our first question will be, share your views on ending cash bail. And I'll start with Kurt.
There we go. Let me unmute myself. Yeah, in terms of bail overall, I think it is important as a judge, and it doesn't always exist, to appreciate what bail is there for and what bail is not there for. There is a certain perception at times that bail is sometimes treated as pretrial punishment, which I believe is absolutely incorrect. It is the wrong use of bail. Bail is basically twofold. One, to ensure the defendant's appearance in court, and second of all, to protect the public. And there's criminal rules. Rule 46 basically sets forth what we need to consider. And it's been amended recently about doing the least restrictive manner in terms of bail, basically to effectuate those standards. And I think cash bail can serve a useful purpose, but when you set $100,000, $1 million cash bail, that's insulting. That is treating it more as a punishment, knowing and realizing somebody will not be able to post that. Bail needs to be reasonable in terms of whether it's cash, 10%, or an OR. The default should be an OR. And you basically proceed from there. Is there a reason not to put an OR bond on? Because if they've got connections to the communities, if the offense is not as serious and they don't have a significant criminal history, you're thinking they're going to show back up, because there is always that presumption of innocence. And that's okay, where I've always proceeded from. Let me give a quick war story. When I was on the bench, had a bail here, I was doing arraignments, and prosecutors there arguing for significant bail. And one of the factors that the rule says we have to consider is the strength of the evidence. And I turned to the prosecutor and I said, what evidence do you have to support this charge? And the prosecutor had no clue whatsoever. Needless to say, that person got an OR bond because the prosecutor couldn't even meet a basic burden. And so I think my basic answer would be, I think OR is the default where you proceed from, and only in extraordinary circumstances do you start moving beyond that. They're not going to appear in court. They have a history of non-appearance, or the evidence is significant and overwhelming of a serious, serious charge.
Thank you. Allison, you will be next.
Thank you. So, I agree with Mr. Hartman that the purpose of bail is twofold: to protect the community and to ensure that someone returns to court. But, there's ample evidence out there that shows that the ability to pay a monetary bond has no bearing on either of those things. What it does do is cause people to lose many times what little they have, like their jobs, their homes, sometimes even their families, because they sit in jail pre-trial just because they can't afford to get out. And, this is a pre-trial detention. There's been no finding of guilt. They don't even really do preliminary hearings here in Hamilton County. They just set that grand jury date within 10 days and they get right around that. So we really need to take a look at what we're doing with bail. We need reform. I will tell you that a lot of times when people don't come to court, it's not because they are trying to evade justice or trying to dodge. It's because they can't get there. They don't have transportation. Things happen. There are a lot of people who don't have unlimited or many resources who come through the criminal legal system here in Hamilton County. And if we make services available to them to ensure that they come back to court, I think 9 times out of 10 they will. So definitely bail reform is something that needs to be looked at, and we're long overdue for that.
Thank you. And Judge Burt, you will be next.
Because the purpose of drug court is to get people connected with treatment as soon as possible, OR is the default for drug court. I try, as soon as the case becomes mine and I have to, what happens procedurally is the arraigning judge will set some sort of bond. Because the drug court cases are the lowest levels of felonies, they should by default be OR or very, very low. During this time of COVID, I basically put out a directive saying I don't want our people, meaning people who are charged with drug offenses, to go to jail. And if they go to jail, I want them to get out on an OR bond, because it's too hard facing all of this to be wasting away in jail. So I came to the decision a long time ago that OR was the default. The cash bail does not help any of the goals that I want to do. What helps is getting people assessed for treatment. And I do agree with Allison Hathaway that the barriers that a lot of people have nothing to do with their wanting to appear in court. Sometimes with addiction, if they are in active addiction, getting from here to there is more than a notion, as my grandmother would say. But we do have, and I'm very grateful that we have 4 members of the Public Defender's Office who handle the majority of the cases that come through drug court, because we don't get a whole lot of people who have a high income who are in the court. But those attorneys are very, very experienced, and they know that we try to get people into treatment as soon as possible. So OR bonds for people who are incarcerated with the felonies that I deal with is basically the default. The only time it's not a default is if there is a probation violation, but my probation officers have orders to have them come see me. And I currently don't lock people up for probation violations because I want to get them involved with treatment. And because every probation officer has a day on my court, there is no reason for Kim Burke, who violated her probation, to be in jail when my probation officer will be assigned to court. They know to have them come to court and avoid the jail, because we are trying to get them connected with treatment or solve the issues that they are finding themselves in while they are in treatment. Thanks.
Thank you. And last but not least, Judge Burton.
Thank you again. It's good to hear so many people who are talking about bail reform. I was surprised when I got on the bench how much bails were set for the bonds for people who have been accused of low-level offenses. With the recent updates, as Mr. Hartman put out, to the criminal rules as to what we need to assess and how we assess how bond is given, it's given the judges more leeway to look at doing more of an OR. And while I agree that $1 million bond is very insulting, because most people can't reach that without the help of a bail bondsman or putting up property, a lot of the things that we see, even in common pleas, is 10,000 to 10%. So the rules say that the bond should be set and 10% needs to be posted of that bond. But when you have someone who's been accused of a low-level crime, generally they don't have the financial means even to put up a $1,000 bond without some assistance from either a bail bondsman or some other surety, which then adds fees and costs onto that, making it even more restrictive, as Ms. Hathaway put up, having their finances even more limited, so it prevents them from getting into court from either bus fare, gas for their car. If we have people who are dangerous, who have been convicted of an aggravated or been charged with an aggravated vehicular homicide or a murder charge, we can always look at 2937-2022, which is a denial of bail hearing, which allows us to go through these factors because they are a danger to the community, they may be a danger to themselves, and there is no condition of bond that would protect them and the community from further harm. We also have tools that allow us to see if the person is a flight risk. Doing a simple leads check to see if they've appeared in court, if they've been charged before, is a great tool that I use. for someone when I am setting a bond, either it be a cash bond or an OR bond with conditions. A lot of the defense attorneys don't like it, but with an OR bond, we can put other conditions on it. Something as simple as an electronic monitoring device, which is an ankle bracelet, or something where they're going in for some sort of treatment with some type of drug and alcohol, or a daily check-in to make sure that they're there where they're supposed to be. So we don't have to have them in the Justice Center. They can stay working and they can stay with their families so that, like Mr. Hartman said, you've only been accused. You have not been convicted of a crime. That's the state's burden. And we should not be ruining someone's life because they're put in jail when they haven't been convicted of a crime. There are certain times when we do need to have people stay in the Justice Center pending trial, but working with the state and working with the defense bar to keep cases moving quickly, even when we do that, those people should not be detained for longer than necessary. And I think it's great hearing everybody talk about that so we can move forward. That's one of the things I missed from 2018, where we were all doing a lot of these together, and you can hear what other judges want to do and what other candidates want to do. And I just think it helps us move forward and do things better at the courthouse.
We have some questions from our chat. So I will ask the first question from our chat. Some have called ankle monitors incarceration because people are still not free. Do you agree? How do you decide if someone should have a GPS monitor or not? And we'll start with Kurt.
Well, I think first off, in terms of electronic monitoring, you got to consider one, are you doing pre-trial? That is prior to them either pleading guilty or being found guilty by a jury, or is it a form of punishment post-trial where they've been found guilty? So that's kind of the first factor you got to weigh is really what is the purpose that you are imposing, whatever. If it's a condition of bail, like we've just talked about, you're basically trying to do those two elements, protecting society as a general and ensuring the return of the person. And so to me, it was more limited in terms of electronic monitoring as a condition of bail, again, with the presumption of innocence. In terms of post-trial, actually a guilty plea or a guilty verdict, the factors I kind of go into is weighing, it is a form of punishment then, because once you've been convicted of a crime, either by plea or by trial, there is a certain form of punishment that they should be imposed, basically trying for rehabilitation and the aspect of punishment. And so in that sense, yes, electronic monitoring is a form of incarceration, is a form of punishment, but it is not a more extreme form in terms of prison. And so it's basically restricting somebody's freedom and liberty for a certain period. Usually I will do it for about 2 to 3 months, keep them under strict probation and kind of work with probation department in terms of trying to wean them off of it. But it's really that factor in terms of, I'm not going to send you to prison, but I want to keep a little bit more control of you and try to work with you through the probation process. So those are kind of the factors that weigh in when it is used in terms of punishment following conviction.
Thank you. And Allison?
Well, obviously I think home incarceration, they call it EMU, EMD, ankle monitoring, it goes by a lot of different names. I mean, it is, I think, a form, in my experience in juvenile court, it's like a form of probation before you've ever been found guilty of anything. So I think we really need to look at when we're utilizing that as a pretrial measure to ensure that somebody's coming back to court. Because it also places a lot of restrictions on people, makes it hard for them to keep employment. It makes it hard for them to get around, get their kids around. It can really put a burden on someone pretrial. Post conviction, again, I think you're looking at if the goal is, I think you can do well on probation, and I think that we can get you into rehabilitative services. Again, you really have to look at when you're utilizing that, and if that's going to be more of a barrier than it is going to be a help. So I think we need judges that are really going to look at these cases, that are going to care about the people that are coming before them and trying to find the right fit if the goal is rehabilitation. If it's just punishment, that's a whole nother story. But I think you really have to be careful when you're utilizing those types of measures, because it really does make it difficult for a person to be a productive member of society and to re-enter society when you've got all these limitations on you. So thank you.
Judge Bearden? Are you on mute, Judge Beardon?
I am on mute. I was not used to, you flipped it up on me. You flipped the order, so you got me on that one. And I'm not as good on this as I say I am, even though I do a lot of Zoom at home. I think a lot of the stuff that both Mr. Hartman and Ms. Hathaway brought up are true. And it is something when you're sitting on the bench that you take in consideration about it being e-incarceration. I do worry sometimes, especially during COVID, we were trying to get as many people out of the Justice Center as possible because of the COVID outbreak, and the numbers have gone down that we were incarcerating, which was good. It did come up sometimes when we were dealing with people who had been accused of crimes where there was other persons involved, and we wanted to make sure that they did stay away. And it is something that weighs heavy when you're on the bench. If I put this on them, I am restricting their access. They have not been convicted of anything yet, but also I need to make sure that there is no violations of their bond, that they are staying on house arrest, so there is no confrontation with that other person, so that we don't have to worry about any violence that way. I'm a little bit different after incarceration with electronic monitoring because we have had a lot of issues. I have had personally issues with people who are working and going to school, and electronic monitors can be cumbersome. They can be bothering. Actually, the reason what changed my mind on this was one of the defense attorneys one time suggested that I just simply allow them to have open access on the electronic monitoring device, which technically I could do, but it made me examine why we're actually putting the ankle bracelet on someone. It's not to control them. It's then why are we doing it? If I'm worried about their safety, about the community's safety, why am I letting them just go around wherever they want and we're just tracking them and they have to keep a piece of electronics on their ankle? And it really changed my mindset on some of those cases. I do like it where we have a consideration of safety and there needs to be a type of home incarceration prior to sentencing. I've done that before where people have been found guilty and we've let them out before sentencing as a condition was on electronic monitoring to make sure that they do return. And that's worked out well sometimes. But it's something you have to consider as a judge. I don't want to have someone convicted or restricted when they don't have to be prior to a conviction. And does the ankle monitor create more of a burden for them getting around, keeping their job with their families? So it's those things we weigh. And I think the person's comment about it being electronic jail is completely fair. It's just something that we have to realize when we're on the bench. We have these tools, but they have to be used with extreme thought. And they can't just be done without any type of thought as to how it'll affect the people that are wearing them and the people around them.
Thank you. And Judge Burke.
Frankly, I don't use electronic monitoring in drug court. What I used to say sort of tongue in cheek is if people want to use your drugs, they're going to use them at home. And the purpose of drug court is to help people get the tools that are necessary to be successful. But drug court does not have the safety issues that my colleagues in general division have. There are not crimes of violence or where there is a victim. So those considerations, I do think that electronic monitoring may be a tool that can be used. But when it comes to possession of drugs or changing scripts or things like that, I haven't used EMD or global monitoring in years, to be honest about it. And frankly, when a case gets to drug court and another judge, the arraigning judge, has set that bond that includes EMD, I delete that requirement. But what I do is I get the person with close monitoring and contacts with regard to their treatment. So they will have to submit to urine screens on a basis to make sure to get information about what type of assessment is needed, or they have to get set up with an assessment that they will have requirements of being reporting 2 to 4 times a week to a counselor. And if they're on probation, there are a lot more reporting requirements. And I also try to see those persons fairly frequently to keep not only to keep track of them, but to figure out where they are in terms of their recovery. So for drug court, that has not been a tool that I have utilized in a long, long time. I don't even think I have utilized it. Thank you.
Thank you. The next question is, given that the sentencing disparities in the court, there's a lot of advocacy for more transparency and accountability within our courts. What are some steps you think that judges can take to get there, as well as would you opt into a program to make your sentencing data public? And we will start with Kim Burke.
I think that data is a good thing. We can't know where we are unless we are keeping track of it. Now, how to figure out apples with apples instead of apples with pineapples is a different thing, because the reality is that some people come into the system with a lot of prior contacts that some would argue would be the basis of where their economic status was or where they lived. And I'm not saying that's the case all the time, but I really do think that we need to look closely as to what we are comparing. In drug court, I try, if they're not, if they don't have to have a felony conviction, I don't want them to have a felony conviction. And the disqualifiers for treatment in drug court because of resources are a prior felony offense of violence. So if you have a murder conviction, the resources are, you won't get your resources through drug court. It would be through my colleagues or colleagues to be, that they would handle that type of situation. But short of that, and also the second thing is if someone is a active person who is trafficking in drugs, those cases get diverted to my colleagues. But beside those two big exclusions, everyone coming in, I'm trying to get them in treatment, and I'm trying to get them to avoid a felony conviction. So resources are, in terms of statistics, are good, but I think it's very important to be able to fairly compare what you're comparing. And I'm not a statistician. Drug court's pretty self-contained and small, and getting that data is something that I don't have a problem at all. I just hope that we all make the comparisons equitable, because sometimes a situation that looks the same may have other factors that, if we're not counting that, may make it different. And I'm not trying to buy trouble. I'm just generally saying that statistics are good because you can't measure where you are unless you have information. But let's make sure that is measuring things that really do try to get the information that we want about the inequalities in the system. Thank you.
Thank you. Allison, you'll be next.
Yes, absolutely. I think there needs to be transparency. There should be transparency. You know, the courts are public. What goes on in them, everybody should have the ability to know about that. There are disparities. I mean, there are disparities nationwide in conviction rates, in incarceration rates, in length of incarceration rates among African-American and Black and Brown people compared to their white counterparts who are similarly situated. So yes, let's look at the data. Let's collect it. Let's analyze it. Why is that happening? And let's do something to fix it. So absolutely, there needs to be transparency. I'm all for a sentencing database. It should have been done. The numbers are there. The data's there. It just needs to be collected and needs to be made available to people. But absolutely, yes, there's disparities, and we need to fix them. Absolutely.
And Kurt Hartman, you will be next.
Here we go. To basically answer the question, yes, I tend to agree with Ms. Hathaway and Judge Burke in terms of transparency. And my history in terms of private practice has been promoting transparency in government. Repeatedly going after local governments, local councils, boards, and et cetera, that try to hide information. And to be consistent and to be honest with myself, the judiciary should be no different in terms of ensuring transparency and getting the information out there. I do think Judge Burke makes an excellent point, though, in terms of making sure we're comparing apples to apples. But that in of itself should not preclude us from disseminating the information. You know, people can compare, people can pull the string and find out that additional information, you know. And one thing I think that we all kind of agree on here is that it's not a one-size-fits-all system. Be it setting bail, be it imposing electronic monitoring, or be it in sentencing. Each person, each case that comes before you is unique. And that's one caveat I think you got to appreciate when you start disseminating information is I'm going to deal with the individual defendant, the crime, the history, the background that's involved in that case. You know, but one thing I do think transparency does help and promote. If you think about it, in the Hamilton County Common Pleas General Division, excluding drug court, we have 15 judges down there. And one of the things I found when I was on the bench was, you know, one of the things we're supposed to consider is similar sentences for similar type of crimes. But I can tell you that I had no clue what my colleagues were doing for a similar crime, and I might have disagreed with them in terms of it. And so we had no basis, no data by which to make sure what your sentence was judge dependent. In theory, and really it should not be judge dependent. There may be slight variations, but I was concerned that we were getting great disparity from one courtroom to the next, depending upon the judge. That's not the way the system's supposed to be. That's not justice at the end of the day. And so I think if we promote transparency, sharing information both with the public and amongst the judges on the bench, it will help for consistency and predictability on the bench. Thank you.
Last but not least, Judge Bergen.
Thank you. Yeah, and it's one of the things that when I got on the bench, I did notice that was an issue. And I'm going to take this a little bit differently and make it a little more personal, is that I wanted to make sure that my sentences were commensurate with the crime and that I wasn't letting any type of unconscious bias creep into sentences that I was giving. And I think Ms. Hathaway brought up, we do have the data, but we don't have the parameters to pull it out in a really easy form. Our computer system allows us to pull cases out based on their age and on their crime, but not on the sentence. It doesn't allow us to compare them very easily. We can do it, and that's what we ended up doing in my courtroom, is that me and my bailiff actually go through at the end of every month and go through the cases that we've done to make sure that the sentences are remaining in line with what I've given out for that same crime with a different defendant. And like Judge Burke said, and like Mr. Hartman said, it is different, but you need to have that data in front of you to make sure that you are basing your decision on the crime and there's not anything else creeping in there. We've had cases where people have been extremely belligerent after being sentenced and are cursing in the courtroom. That doesn't make a difference as to the crime that they committed. It may be as to the rehabilitation, but you don't want that to affect. You don't want someone who comes in that looks different than you or acts different than you in any way affecting how you sentence that person. And we need to have that data open and obvious for everyone to look at so that you can see that there may be some issues that you're having as a judge, so you can make sure that you work on those and correct those before they become a problem. And letting that data go out to everyone only will build more confidence in the court that justice is being handed out fairly. It'll make us as judges go out and engage with the public more to explain why sentences are being given. This mystery of why someone's sent to jail and why they're not sent to jail is horrible. And as a judge, I try to explain that when I'm on the bench sentencing someone. But people in the community need to know why it is too. And that data will be a great starting point for that. We are working with the case management system and the clerk's office to see if we can get that data more easily disseminated. We do have sentencing data now through the Supreme Court that shows sentencing data per crime in the county. And Chief Justice Maureen O'Connor recently, her last initiative has been to make that data more open and working with all the local governments, all the local courts, so that we can have a combined system. So in Ohio, you know what people are being sentenced for and why they're being sentenced for.
Thank you. And Dr. Zaria Davis, if you had any questions or anything coming out the chat.
Yeah, there's one here. This is just in regards to community engagement. The question is, oftentimes we have people from our communities that are interested in meeting with judges, sharing their concerns, and just, being able to give feedback. And so the question is, are you all open to meeting outside of, election season? Are you all open to meeting with the community and discussing what the community feels are specific needs that should be addressed with our court system? And I will, we can just go in the order of who I see people. So I'll start with Judge Burke.
Absolutely, I'm open to that. One thing about drug court and rehabilitation, it's fluid, meaning that the type of drug sometimes is influential, the person, and getting feedback is very, very, I think, helpful, because while we as judges like to think that we have full information when we're resolving something, a lot of times the best information I get is from a family member or someone else in the community that really tells me about a factor that really is paramount or very important in recovery. An example I will give is recently there was a person who had a significant medical issue that they were suffering from, and that was something that they needed to get the medical situation as much as they could under control before they could even think about the substance abuse issue. But this person did not have a place to go. They were living on a porch. And I didn't find that out until someone made mention of it. And that really did change the entire way that we looked at this, because as most of us know, if we don't take care of the primary needs of someone, we can't get to the other needs of them. A person has to be safe. A person has to be fed. A person has to have at least enough health that they're not dealing with something acute. And I think that the more information that I get individually about somebody is helpful, but I also think in terms of the community, because substance abuse crosses all of our community, I think it's helpful to get information. And when I talk to people in the community or people in the grocery store, they will share with me what their situation is and what their concerns is, and things that they think will be helpful. And I think the more information, at least with drug court, that is helpful. So I am open to that. I will not talk about an individual case, but with drug court, the more I know about situations or the community or addiction, I think the better judge that I will be. Thank you.
Thank you. Allison?
I'm gonna steal a slogan that that one of my colleagues shared with me, and it really made me think about it. But you don't know where you don't go, right? And this is what I do. I mean, as in my years as a public defender, serving so many people in our community, I go to their homes. I get out in the community, I see where they come from. Like you're not gonna know how to help people. You're not gonna understand where people come from unless you get in proximity with them. So absolutely, judges are here to serve the community. And if you don't know the community you're serving, how in the heck are you going to do a good job serving them? So across the board, you need to be out in the community. You need to be in proximity with people, see where people come from, listen to people, listen to their concerns, show compassion. If you really care about doing a good job and being an administrator of justice, you've got to get with people, you've got to hear people, you've got to listen, you've got to learn, you've got to be open. And not just with some groups, not just with some sects, not just with some people who have money or don't have money, or some people of color and some people of another color. You have to be in proximity with everyone that you're serving. So absolutely, I'm happy to be in the community. I already am in my current job, so it wouldn't really be anything different than what I'm already used to.
Thank you. Kurt Hartman?
No problem. To answer the question, basically, yes, willing to go out there and get information. In Ohio, we do elect judges. And part of the reason we elect judges, we have elections for judges, is that judges reflect the community. And you cannot know that community unless you're out there and involved. And while we all live in Hamilton County is a diverse community. And as Ms. Hathaway said, we represent the entire community as judges. And our obligation is to that community. And so it's important, you know, the question presupposes, and I kind of agree with it, some judges you get out of the courthouse only during election season. And that is not a public servant. You know, notwithstanding that we're not on a city council or board of commissioners, we're still public servants. And we're accountable to the public, and we got to know what's going on in our community. And I think that occurs both in terms of meeting with groups to be basically what I characterize as a sponge. More information, the more feedback I can get from the community, the better I can become as a judge to understand what's going on and to deal with the people who come in my courtroom. And so that's important. But I also think it's important as a judge to make sure you're willing to do that and not lock yourself, if you will, in the courthouse. Just give a quick war story. When I was on the bench, one of the issues I had a receivership for a lot of Section 8 housing. PE Alms, the Alms Hotel up in East Walnut Hills, was in receivership. And there were various issues about what was going on in terms of its repair, was it being upkept? And yeah, I could sit in the courtroom and let the attorneys make arguments to me and then bring people in to talk to me. But I said, though, as a judge, let me go out there and see. And I was able to go out to the PE Alms Hotel, meet with the residents to actually see what was going on. And I proved that on the bench. And I think it's an obligation just in either for cases you have or even in the abstract in terms of general things, what's going on, to get that information to make you a better judge, to make you a better public servant, because at the end of the day, that's what we are. Thank you.
Thank you. You're already unmuted. Go for it.
I did. I was not going to get caught flat-footed again, Ms. Davis, so I appreciate that. That one I could figure out.
Yeah, and I do have a follow-up after you finish.
Okay. Basically, I started out in politics back in 2001 when I was a public defender. I worked for a man named David Crowley, who was on City of Cincinnati Council. I ran his first 2 campaigns. And one of the things that David always taught me, he was a former social worker, is that you need to be in the community to help the community. And as Mr. Hartman brought up, we're not city council members, we're not state representatives. We hold a different role because we are on the judicial branch. But it's even more important in some ways for us to be out in the community. And being a lifelong Cincinnati, Hamilton County resident, I was not surprised when I went out that people wanted to talk to me about what was going on in the courts, but always incredibly respectful, with interesting questions or concerns that they wanted to bring up, that they needed to know that someone was listening. And sometimes that's the most important thing, that you're in the community, you're hearing these concerns. A lot of times people know that there isn't an easy solution, but they want to make sure that we're listening and that we're working to fixing things. One of the things I really like with Amos, I've been to a couple of the events when we've talked about bail reform and bond reform and mass incarceration. And sitting in those and listening to people in the Ohio Justice Policy Center and the Ohio Innocence Project and their things, and listening to people talk about their experiences in the criminal justice system, as a judge, a lot of times I cringe that the way that they've been treated. And sometimes I'm hardened by the way they've been processed through the system and they've come out and everything's better. But a lot of times that's not what happens. And as a judge, it's our responsibility to listen to those bad stories to make sure that they don't happen again and to make sure that we are doing better. And we can't be in the ivory tower of the courthouse to do that. When you're sitting there in the bench with your robe on, people are not as forthright as they normally would be when you're out in the community. And it's important to be out in the community and to hear those concerns so that we can act on them when we are on the bench.
Thank you, thank you. And so we have a question from our Facebook viewers. If someone wants to observe in the courts, how would they go about doing that? And are you all comfortable with people observing in your courtroom? And I'll just open this up.
I mean, I'm not a sitting judge, and all these other people amongst me have either been a judge or are currently a judge, but I would encourage people absolutely to come into court and to see what's happened, see what is happening there. In the adult world, it's public. There's a few more limitations when you're talking about juvenile court, but in my work with our participatory defense network, that's what we're really trying to do, is get the community involved to see what happens in juvenile court and see how children and families are treated, and the things that go on and the obstacles they face, and to also provide a support Yes, I would absolutely be open to people coming in and watching. I think they should. I definitely would encourage people, go in and watch as much as you can, learn what's going on, see it firsthand. Because a lot of people, again, you don't know where you don't go, but go there and see what you can do.
Anyone else want to jump in?
Oh, I'll echo those concerns. When I was on the bench, I welcomed it. On occasions you have, school students come in and watch, but even just people from the general public come in, and courts are open in Ohio, appropriately so. I mean, justice has to be open, and people need to be there. Hold us accountable, hold the system accountable, and part of that is having eyes on what's going on in the courtroom. And even when that happens, there's some down times, if you're not in the middle of a trial and you're just doing consultations with the attorneys or pleas, every now and then you go out and talk to the people and kind of help educate them. I'll talk to people who came into my courtroom between matters, just kind of give them a brief education, answer their questions, why this happened, what happened there, not the particulars, but general education. And that's it. I think ability for the public to come in, observe, find out what's going on is a great educational tool for the general public, and it's a good accountability to the courts.
I agree with what has been said. My courtroom is open. I encourage people to come down. Drug court is different, and I think I am proud of what we try to do with people and trying to get them in treatment and having the resources that are necessary to be successful. If a person comes closer to, my dockets run in the morning, they're pretty big traditionally. If you come closer to 11:30, there'll be enough spacing between the matters that we'll be glad to, I will not only talk to you, but introduce you to the team and try to explain what we do in drug court. I think that that's part of our obligation as public servants to help explain. And drug court has the mechanism that if you come about 11:30, things have slowed down a little bit, that you certainly can get information. But if you come in the beginning, you can do that. And usually by the time the docket is through, we can tell whether or not it's a client of drug court who is there, because we've gone through the names and we try to identify who is there and help them with their issues. So if Kurt Hartman came in the courtroom, by the end of the docket, we could probably identify that he was not somebody who was on the docket for the day, and coming to observe. Occasionally we do that. A lot of times it's with medical or mental health professionals that kind of want to see how we are able to utilize this tool. But I certainly welcome it, and I think it's an important part of the judicial system.
And I know we're getting short on time, but yes, my courtroom's always been open. Some people may know more than others about Court Watch coming into my courtroom, and it's good. I enjoy it, yeah. And it's always informative. We do have different Court Watches set up around the community. A lot of the community councils have a Court Watch, which is a lot to see what's going on with sentencing for things that happen in the community or what's going on with cases. We also have other Court Watches that are coming in to watch the judges to make sure that they're handling cases properly and to get a better feel. So that's always encouraged. Due to COVID, we've had to restrict how many people come into a room. And I'm not going to jump, I don't want Mr. Hartman jumping on me this one. I'm not restricting anyone from coming into the courtroom, but due to the COVID numbers that we have coming in, we are trying to restrict people who are observing. We set up my courtroom now so we can spread more people out if we have that issue. Also, we've had several people where we've had cases of interest that we're doing via Zoom that we're allowing them to view through the Zoom link itself. Our court reporter's there, so it's not recording, but it's still an open feed, and the Supreme Court has said that we can use that for openness. It's been helpful for defendants, it's been helpful for counsel who can't come to the courtroom, and it's just been as helpful for people who want to view the case, being concerned bystanders, family members. So anything that brings people into the courtroom to help alleviate the mystery of the court process is always good. And once again, going back to Hamilton County, people who come into our courtrooms are generally very respectful of what's happening, and are either there for support or concern or for information. And as judges, it's our responsibility to nurture that and make sure that people keep coming back and get the information they need.
Thank you.
Well, we're running out of time, so I just want to thank you all again for joining us today. And I really was excited about this one in particular because we have incumbent judges, candidates who are running for judge, as well as from both sides of the aisle, to give a perspective to let our voters and our viewers know a clear distinction of what all of the views are on the court, what diversity of the court really looks like. I think this group is very diverse in thought, so I hope it was very helpful to all of the people who are watching, all of the people who will watch after it's posted. Judges matter. This is something I'm super passionate about this year. You'll see it all over my page, and some of you I've interviewed before and or been in your courtroom, and it's been awesome. So I will let everyone give a closing. You only have like 30 seconds. So we'll start with Kurt.
No problem. Appreciate the opportunity and putting on this program tonight. I would just say the one thing that I think everyone can take out of this is, as you indicated, we're from both, bipartisan panel here, but really a nonpartisan panel. And that's the key thing, but I think that we all indicated tonight in terms of justice and the commitment to justice. It's neither a Republican or a Democrat thing. It's an innate thing that somebody has. And I think that's the key thing for the public. We want people who is going to do it right, who's going to treat people fairly and have a commitment to that system of justice that we have. That is colorblind, that is blind to social economic conditions. That's what we want. That's the key thing. I think I have that commitment and would appreciate people's support this November. Thank you very much.
And Judge Bertian.
I knew you were going to do this, Suzanne. I appreciate you having us here tonight too. To answer Ms. Davis's question real quick that you put up, we are working right now with the Ohio Supreme Court about getting our data fields lined up so that we can use them all across the state for tracking sentencing, and we're looking at making that system work within the CMS. I was elected to the bench 2 years ago. I have had about 18 months on the bench as it stands right now. It is a steep learning curve. It is the hardest job that I have ever had, and it is the one that I enjoy the most. It is an awesome responsibility that I serve every day for the citizens of Hamilton County. I do believe that we need to view each case that comes before us individually and give it the respect that it deserves. And I feel that when you come into my courtroom, you will feel that. So with the last 2 seconds, I would appreciate your support this November. Make sure that you do have a voting plan. If you're going to vote in person, if you're going to vote absentee, you're going to vote early at the BOE, make sure you plan it out so you stay within the rules so your vote does count, and vote all the way down the ballot for all the judges. Thank you.
Judge Bird.
Thank you for the opportunity to be here. It really was a great experience, and I was really impressed by the questions and the level of discourse. As everyone knows, judges are important, and I think that everyone should do their research as much as they can and make a decision that they think goes with their system and their values. I think the most important thing, and I think I've seen it all across the board tonight, are people who are committed, people who are ethical, people who are non-biased. I think that those qualities are the ones that are the most important. And I know that those qualities are important when helping people with addictions. So I would ask everyone who is here, please register to vote, and please vote for all of the judgeships that are available. I am the drug court judge. I would humbly ask you for your vote, but it's very, very, very important that everybody get out there and vote. So thank you.
I guess I'm just going to go. Again, thank you so much for having me. My name is Allison Hathaway. I'm running for Common Pleas Court. I'm running because I feel like we are long overdue for change. There's not enough justice in our courts the way it stands. And we need to be, we need judges who look like the community that they serve, who come from different backgrounds and different experiences, who are willing to listen, to make every case that comes before them the most important case, and to work on things that are systemic as well, to look outside of their individual courtrooms. Obviously, we want to be fair and just, and weigh the law, or weigh the facts in the law appropriately in every case. But we also have to look at why we have disparities. We need to get the data around that there are disparities. What are we going to do to fix those disparities? What are things that we can do to end? We can work on bail reform. We can work on mass incarceration. Once we get numbers and we get statistics and data, we can start working on those things. And that's what I want to do. So if you want to know more about me, hathawayforjudge.com. I would love your vote in November and your support if you want to see change. Again, my name's Allison Hathaway, running for Common Pleas Court Judge.
Well, thank you all again for joining. Thank you, Dr. Zaria Davis, for hosting this with me. And please vote. Vote local. They're our only savior to our court system currently. Good night, everybody.
Good night.
Yeah.
Night.